you're investing in California real estate, picking the wrong entity could wipe out your entire portfolio. Every week I talk to investors who set up an LLC or worse, a land trust, thinking their assets were safe until, unfortunately, a lawsuit proves them wrong. I'm Ali Talai, an estate and asset protection attorney and founder of Tai Law Offices, and in this video, I'm breaking down the real differences between LLCs, land trusts, and corporations. We'll talk about when each of them will make sense and which one to avoid if you want a real protection in California's lawsuit-happy environment. So you might be asking, what is the best real estate entity for California investing? And I could guarantee if you're buying a property in California, you have wondered if you should hold this new property in an LLC, if you should hold it in a land trust, or maybe even a corporation, which you should probably stay away from. I get this question almost every day, and the truth is, it really just depends. As much as I don't like to say it, but it really does depend. There is no one size fit all, but once you understand how each structure works, you'll have much better understanding and knowledge, and you'll be a lot more better equipped to answer that particular question. California is one of the most litigious states in our country. Slip and fall claims, habitability lawsuits, tenant injuries, these happen all the time. And if your property isn't structured properly, your personal assets, your home, savings, everything could be at risk. Let's talk about LLCs. They could be very strong protection, but there is one big if with LLCs. LLCs are hands down one of the most common setup for California investors. They create a legal wall between you and the property. If someone sues you, they're suing the LLC, not you personally, and that's great. But, and this is a big one, if you're the one who manages the property, especially in a single member LLC, if you're the one who ignored the leaky stairway or the broken light, guess what? You could still get pulled into the lawsuit personally. Courts here in California don't treat single-member LLCs as strongly as multi-member ones. So if a creditor gets a judgment against you personally, they might be able to go beyond a charging order and actually grab the assets you have in your LLC. So yeah, LLCs are powerful, but they are definitely not magic. They cannot do magic. You've got to manage them right. And if you're using a single member LLC, here are a few ways that you could make your single member LLC stronger. Number one, you could use a Wyoming holding LLC to own the membership interest of your California LLC. Wyoming has stronger and better asset protection laws for their LLCs, which can make it harder for creditors to break through the LLC. Wyoming holding LLC, membership interest, this adds another layer of defense, and when structured properly, it can make a huge difference in a lawsuit or creditor scenario. The other thing you got to keep in mind, and you got to do, is you got to keep records. You got to keep good records, clean records. You got to make sure you have a detailed operating agreement, comprehensive operating agreement. You got to make sure you don't commingle the funds. Personal funds and business funds should not be commingled. That's really important as well. All right, so let's talk about land trusts. They are a great tool for privacy, but they do not offer any asset protection. A land trust is actually a kind of a revocable trust that holds title to your real estate. You can stay in control, but your name, if set up correctly, will not show up in the public record. So it can provide a great deal of privacy, which again, as part of asset protection, one of the layers that we try to put together is creating a plan that provides privacy. We don't have to tell everybody what we own, where they are. And so land trusts can be used and are used. We use them a lot in asset protection planning, but they're definitely just one of the bricks in the entire plan. But here's the problem. I talked about this already, but the problem is that they don't really provide asset protection. If something happens on the property, they can still sue you. Whoever, the tenant that fell on the property, they can still sue you as the beneficiary of the trust. The fact that you have the power to revoke the trust. So for that reason, there is no real liability barrier between the property and whoever is suing you and yourself. And usually they're not enough by themselves for asset protection purposes. Where these land trusts shine is when you combine them with an LLC. The LLC will own the beneficial interest in the trust, and the trust holds title to the actual property. You get privacy plus the asset protection that you would want. All right, so let's talk about corporations, why they're usually a bad fit for real estate investors. I get to hear, unfortunately, more often than I like to, questions like, should I put my rental property in a C corporation or an S corporation? Short answer is probably not, and here's why. Yes, corporations do give you liability protection in some cases, kind of similar to LLCs, but they come with a major tax and asset protection downsides, especially for long-term real estate holdings and investors. All right, so let's initially talk about charging order protection. So if you get sued personally and you own shares in a corporation, it doesn't matter C or S corporation, a creditor can potentially take those shares from you. Corporations don't offer the same charging order protection that LLCs do, so you are more exposed. But I think really taxes is the real deal breaker, and the reason why I don't in most cases recommend my long-term real estate investors to actually use a corporation. If a corporation, C or S corporation doesn't make a difference, distributes property to a shareholder, let's say a piece of real estate that it owns, Internal Revenue Code Section 311B kicks in. The IRS treats the transfer as if the corporation sold the property at fair market value, even if no money was exchanged. So if the basis of that real estate property was lower than the fair market value of that particular property, the corporation must recognize a gain, which creates a tax bill. This is horrendous. This is horrible. In a C corporation, that gain is taxed at the corporate level, and you pay again if the property or cash flows to you as dividend. That is the famous double taxation of C corporations. In an S corporation, you avoid the second layer of tax, but the gain still passes through to you and you're taxed on it. Either way, it's not ideal. And here's another issue. When you pass away many years from now, the shares in your corporation might get a step up in basis, but the real estate that you place into that corporation does not. So your kids could be stuck with low basis property, the real estate that was in that corporation, and when they go to sell this property, they're going to be stuck with a huge tax bill. And if you compare that to a real estate that is held in an LLC or in your personal name, in most cases, the property itself gets a full step up in basis at death, and it could wipe out a major amount of capital gains taxes. And let's not forget the corporate formalities, the bylaws, board meetings, shareholder resolution. This is a lot of work for a structure that is not really built for holding rental properties. Bottom line is, unless you're flipping homes, raising capital, or running a real estate development company, corporations, whether C or S, are usually a bad fit for long-term buying and holding investors. You're better off with an LLC. So what should you actually do? If you're just starting out with one or two rental properties, setting up a single member LLC per property could be a solid foundation. This approach offers liability protection and could keep your operation straightforward. For those who are concerned about privacy, incorporating a land trust can be beneficial. By placing the property's title under the name of the land trust and then having your LLC named as the beneficial interest holder of the land trust, you are able to get your name off of public records and have the ability to still protect your asset because you've connected it to a limited liability company. And the one last thing that you got to keep in mind and be super careful is that when you do all these things, you got to make sure you do it in such a way so that your California property taxes don't get reassessed. All right, so as your portfolio grows, you can consider doing the following strategies and implementing them. One of them is that you could set up a management LLC as an entity that would handle the day-to-day operations. It will collect rent, it will take care of the maintenance, it will communicate with the tenants. The one key factor here is that in California, if the LLC manages property it doesn't own, or it's a separate entity from the entity that holds the LLC, you gotta have a broker's license. The other idea is that you use separate LLCs that would hold each property. So instead of putting everything in one LLC, you put them into separate LLC, and the idea is that you're going to isolate the liability, making sure that the problem from one property doesn't affect another property. Another idea is to implement a Wyoming holding LLC. By placing a Wyoming holding LLC in your structure and having that LLC own, that allows you to bolster the asset protection for the California LLC, allows you to have greater privacy, and makes it a lot more difficult for a creditor to be able to gain access to the assets within the trust. Remember, the key with asset protection is to make it more difficult. The more difficult it becomes, it's much harder for them to get a hold of the asset. They may just give up, they may not go after it, or at least it'll give you some sort of leverage to be able to negotiate with the creditor. And lastly, consider using an irrevocable asset protection trust. For long-term estate planning and asset protection planning, having an irrevocable asset protection trust can offer additional safeguards, especially when you combine it with your LLC planning, having your LLC's membership interest owned by this irrevocable asset protection trust. Remember, the effectiveness of these structures hinges on proper maintenance. You have to make sure you maintain separate bank accounts. You got to make sure you keep accurate records, and you adhere to the formalities as much as we don't want to. You got to make sure you do the minutes, you do the meetings, all those things. Let me share some common mistakes I see investors make when choosing entities for California real estate. All right, so the bottom line here is, for most California investors, LLCs hit the sweet spot. They're good for asset protection and liability protection. They provide flexible taxation and fewer headaches than corporations for sure. Land trusts, they are great for privacy, but if you want to implement asset protection planning, you will need to pair it up with some sort of stronger structure. Usually, again, as we discussed, some sort of an LLC. Corporations, they have their place, but probably not for holding rental properties. Even the best structures won't protect you if you don't operate them the right way. So don't miss my next video where I'll talk about how to protect your California rental property from a lawsuit. Don't let a lawsuit ruin what you have worked so hard to build. See you in my next video.